First off, welcome back from spring break. And like true law school fashion, we're asking you to hit the ground running with the one on Moot Court. We appreciate all the hard work that you put into your briefs. Now, with the appellate process, you're going to be engaging in the second half of it, and that's arguing in front of the court. And before anything else, I'd like to introduce the directors for the one on Moot Court process. We have Alexander Cromwell.
That's close enough. Cornwell.
Sorry.
You don't need my name. That's good.
And Michael Matthews. The assistant directors are Tracy Johnson. And Mark Godfrey and Rebecca Allen are the other two assistant directors. They cannot be here today. My name is Kevin Lubring. I'm going to be the fourth assistant director. If you see any of us in the halls, just pull us aside if you have questions or want to know about the process or the scheduling of events. Some important dates. Be sure to sign up for the practice rounds by 5 o'clock this afternoon. The practice rounds, it's not required that you have your entire presentation ready, but coming from someone who did not have his entire presentation ready last year, you want to be as far along as you can be. It helps a lot. It allows the practice judge to give you more critiques, give you more feedback, and helps you be more prepared for the one-on-one court when you're actually presenting in front of judges. And important dates for the actual round, next week Tuesday, Thursday, and Friday, and the week after that, the 16th Monday. Those are going to be the actual dates of the competition. Granted, not everybody's going to be going on each day. I'm not entirely sure how we.
Those will come out in the next few days. We'll post who's going to win.
Okay. And then also this Thursday from 9 to noon, the Western District of Missouri is going to be in session in the courtroom. I don't know if that's required for your classes, but it's definitely a good idea to attend so you can see professional lawyers arguing in front of the court and seeing their styles and how they respond to questions. And jumping right into things, the judge for today is going to be Professor DeNoyer. Unlike in the real session, this is only going to have one judge. In the actual competition, you'll have 3 judges staring you down. Unfortunately, we were going to have 2 competitors, but Andrew Blackwell couldn't make it today, so now we only have Audrey Danner.
She's all you need.
Let's just get right to it.
Yeah, I guess I can set it up and down work.
Tell me when you want.
Okay. I guess I'll brag myself. You want to? Okay. Hi, guys. My name's Audrey Danner. I'm going to give you a brief kind of background of the case really quick. This is a case between the petitioner, Andrea Tuckerman, a student at the Betterly County School District, who is the respondent in this case. This is an appeal from the 14th Circuit, which is a fictional circuit. You'll find that often in moot court, that you're not dealing with a real circuit, unlike you guys are in your actual case, so that you guys have good precedent coming out of those. Here, Ms. Tuckerman was blogging online, said some derogatory and defamatory statements about another student. The school disciplined her for those actions, and then she subsequently sued the school district for the First Amendment claim of violating her freedom of speech. So I guess with that, I will kind of get into it and you'll learn the rest of it as I go along. I'm the respondent today. Mr. Blackwell is going to be your petitioner. So the respondent opens a little bit differently, not very differently. You just do less facts than the petitioner. So you'll hear less facts from me than you would hear if you were the petitioner in the case. So with that,
I'll get there.
I'll get started.
And just so you know, Audrey definitely knows what she's talking about. She's very good. She won the moot court competition in the school, arguing before the Supreme Court of Missouri, and they said that she was the best advocate that argued before them. So pay attention to Audrey. She knows what she's doing. Unlike me, who's never been a judge.
And traditionally, your judge will be in front of you, so I'll have to kind of look sideways, but I'll use you all as my judge too. So, may it please the court? Your Honor, my name is Audrey Danner, and I am the respondent for this. I represent the respondent for this case, Betterly Hills County School District, in this matter. We are here on the petitioner's appeal from the 14th Circuit from their ruling that Ms. Tuckerman's speech created a substantial disorder and disruption in the school and collided with the rights of another student to be let alone. And for the following reasons, I ask that this court uphold the 14th Circuit's decision holding that the respondents were allowed to discipline Ms. Tucker and her speech and did not violate Ms. Tuckerman's First Amendment freedom of speech rights. The First Amendment to the Constitution provides Congress shall make no law abridging the freedom of speech. However, not all speech is protected. This court has created a special body of law for public school students. The landmark case on this special body of law is Tinker v. Des Moines Independent School District. Tinker states a student's speech must materially and substantially interfere with the school's administrative order to be prohibited.
Okay, so Tinker says that it has to substantially and materially disrupt.
Yes, Your Honor.
Why are we going to follow Tinker? When Tinker was, what year was Tinker? In the 60s?
Tinker was a 1969 case.
So we're following a 1969 case. And didn't Tinker say, first of all, that it had to be on-campus speech? Is it in or out of the classroom?
Yes, Your Honor, that is my first point under this case, is that Tinker applies to all student speech, any student speech, whether it occurs on campus or off campus.
But in Tinker, they said in class or out of it, and then went on to say that means in the cafeteria, during school activities. So isn't this different when you're saying in class or out of it? It didn't actually mean off school premises?
Well, Tinker itself states protections and limitations prescribed under this standard do not merely embrace the classroom hours. They apply after the last school bell rings, whether it be time, place, manner, or type of behavior. Tinker applies.
Okay.
So the issue in this case here is what standard should the court apply when deciding whether a school district has the authority to discipline students for internet speech. Here, Tinker applies to this case. For the following reasons, the Tinker standard applies, and the 14th Circuit should be upheld. The court's Tinker standard applies to in class or out of it, Your Honor, as we just mentioned, because several other courts have used this, and their reasoning follows that it's not where the speaker was located, but it is the transition of the speech through the schoolhouse gates onto the school campus.
Let me try to understand what you're saying there. So you're saying that this was because this speech was on the internet,
Correct,
on a blog, correct? And the internet is a series of tubes, and those tubes have gone to the school now.
The effect of the speech has reached through the schoolhouse gate and has created a material and substantial disruption to the school.
Wasn't she at home when she made the speech, however, when she wrote on her computer?
Yes, she was at home. She created the blog on her own computer.
Her private computer?
Yes, Your Honor. But the speaker does not, in this case, and as other cases have held, the speaker does not have to physically be present on the schoolhouse, on school property.
Well, no case has actually said that. When you had all the cases that came after Tinker, all his progenies, you had Morse, Bethel, Hazelwood, they all said that it was speech, speech was regulated on school premises. So isn't Tinker a bit of an anachronism? That it existed in the 60s, and now we have the internet, as you're going to say. The internet changes things, and since the internet changes things, shouldn't we change our standard and maybe not follow Tinker?
Tinker provides the guiding light in this situation, and it has been in place for a long time. Lower courts have used this guideline as well when addressing internet speeches. JCV Beverly Hills School District noted that many courts analyze off-campus speech, which is brought onto campus under the Tinker standard of substantial disruption without regard to the location of the speech. The off-campus speech did not insulate a student from the discipline by the school. It's a clear test happens when the speech happens on the school grounds. However, Tinker still applies off school grounds. Did that answer your question, Your Honor?
Yeah, I'm just curious if it applies off school grounds. What about, let's say, I'm at the movie theater with my friends, I'm a high school student, I say a rumor that a student is cheating. That movie theater rumor now goes to a football game, and then it goes to inside the classroom. So how is that different than the internet, where eventually it reaches in, but it started outside?
I'm not sure I understand your question, Your Honor.
what I'm trying to figure out is you're saying it's different. Tinker applies, and it can apply to this case because it eventually affected the school.
Yes.
By that rationale, anything I do outside of school that eventually reaches the school will then have the Tinker standard. So let's say I'm talking to my friends and I gossip, like teenagers do, maybe lie, and all of a sudden that gossip and lie reaches the school eventually. So wouldn't we say somehow that now I should be punished for gossiping with my friends?
Yes, I understand now, Your Honor. The distinction between the internet and the gossip that you mentioned is that in this case, Ms. Tuckerman's speech was directly targeted at the school. She distinctly mentioned another student and a principal, and another teacher, and in her blog post, she knew that her readership was other students. She knew other students were watching this, and she knew that her blog post had the ability to be published beyond just her home and her home computer. Here in this instance, that publication went from her computer through the schoolhouse gates to the students within the school, this causing the material and substantial disruption. The disruption here was that students were talking about this blog post in the lunchroom over multiple days. There was a spike in cell phone violations from the school, which the school had a policy on no cell phone use on campus. These are directly related to Ms. Tuckerman's blog post.
Okay, so you're saying that let's just assume, Argendo, for this moment that Tinker applies, and you're saying now there was a substantial disruption.
Yes, there was.
Because there was a high use of the cell phone spikes.
Yes, and there was the lunchroom chatter, classroom chatter that then provoked some of the teachers to have to go to the vice principal, Ms. Bliss, and then Ms. Bliss then had to conduct an investigation on the cheating.
I'm not sure exactly if how that's substantial disruption. I wonder if you could help me understand it, because students talk in the lunchroom about many things. I don't understand how that is substantially interfering with the pedagogical interest of the school.
Well, as you know, students do talk, but that talk can go beyond the lunchroom into the classroom, or, and particularly to this specific student, Mr. Brendan Walsh, who was listed in this blog post that Ms. Tuckerman created. She was specifically interfering with his right to be let alone and his right to kind of be within the classroom without interference.
Before you said that he or she targeted the school and through the schoolhouse gates.
Yes.
Are you suggesting because she mentioned Mr. Walsh in the blog post that was reasonably foreseeable?
That is one reason why Ms. Tuckerman could reasonably, or the school officials for that matter, could reasonably foresee that Ms. Tuckerman's speech would cross through the schoolhouse gates and reach the school. The case of Kowalski v. Berkeley County School District, a 5th Circuit 2011 case, noted that it was, whether on campus or off campus, it was the intent in creating the post that the student created, the targeting of a fellow student within that post, the anticipation by the author of another reader construing the post as regarding the school, the audience of the post, and that the author knew that her post could be published beyond the home and could reasonably expect to reach the school environment. Those are not controlling, but several factors to look at when deciding whether the intent and the reach of the blog post could foreseeably reach the schoolhouse.
Okay, so let me understand this then. You're saying the intent and foreseeability. According to J.S. X. Snyder from the 3rd Circuit, they raise this hypothetical in a concurrent opinion. A student writes a blog about a political issue. The example was gay marriage. And because of the blog post the student wrote in support of gay marriage, it caused disruption at the school by other students. So should we then punish the disruptors and not the student writing the blog, or should we punish the student writing the blog? How is that different or the same in this case?
It's the reach of the speech of the author that was being disciplined here. So I would be happy to supplement the court with a brief on that case. However, I'm not directly familiar with it.
Thank you.
In continuing on here, lower courts overwhelmingly use this Tinker standard. They go into discussion in cases such as Wisniewski versus the Board of Education of Weedsport Central School District and Doniger v. Nyhoff. They both say that it's a foreseeability risk, it's a foreseeability of whether the speech can reach the campus. And if you use that, the school has reached that hurdle in that it was foreseeable, as we just discussed. With that being said, I will draw to conclusion. For the previously mentioned reasons, I ask that this court uphold the ruling of the 14th Circuit in that the respondent's actions in disciplining Ms. Tuckerman for her off-campus internet speech did not violate the First Amendment rights of Ms. Tuckerman under the applicable Tinker standard. Thank you.
That wasn't practice or anything. That was really good.
Yeah, that was not scripted, as you can tell. That was a little. But
If you guys have any questions for Aubrey or Professor Denoyer about what they just did, stylistically, the sorts of choices.
I'm sorry, I walked away. I'm done.
Anybody have questions?
Scott.
yeah. Oh.
Is that how you would typically deal with a case that you're not familiar with? Is that the response you?
Yes. Never, ever, ever lie that you know a case. If you don't know it, tell them, because they will figure out that you don't know it in further prodding you on questions. So just be up front. I'm sorry I'm not familiar with the facts of that case. I'm sorry I'm not familiar with the holding of that case. And then always follow up with, I would be willing to supplement the court with a supplemental brief or something to that effect. But I would suggest never, ever to fake it and lie to a judge that you know something that you don't.
That was very good that she did that. That was really impressive. I know it might seem impressive more to talk and know the case, but if you don't, and there's a good chance you will not know all of the cases, hopefully you do in this set of problems. With this problem we were dealing with, there's so many cases from so many lower courts that it's understandable that she would not know a Third Circuit case necessarily, and would then have to say, I'm going to supplement this. More questions?
Questions about how to organize your information while you're up here, because you probably saw me fumbling with some papers. I recommend not to try and fumble with papers. It distracts the judges.
I mean, how did you handle being asked a question by a judge, responding to it, and kind of finding your way back to getting back on track to your facts, what you wanted to present to the court?
Did you guys hear that? How do you get asked a question, get taken off your roadmap when you get back on? You either figure out where you are, or you just keep running with what the judge just asked you about. So I think you all have kind of elemental type thing. If you're talking about element 1 and the judge gets you off track to element 3, finish element 3, then go back to 1. That's how I handle that. And you just kind of have to have it in the back of your head that I didn't finish that point, I'll go back and get to it. But you want to address what the judge is asking you at that moment, so you can't just kind of, I'll get there in a second, judge, hold on, that's in my third point, I'll get there. You have to address what they're saying at that time.
And I liked Audrey said, if I answered your question, Judge, she went on and did that. It's very important to directly answer the question the judge is asking and not trying to escape it and just get to your talking point. If the judge asks you a question, answer it. And you did that.
I would also say that you did a really good job of paying attention to what we asked. I think the judge wanted to hear something about foreseeability, kind of go about foreseeability, and then you expounded on foreseeability.
Yeah, that was really well done. Did you guys catch that when I asked about the foresee? I was trying to elicit a response. A lot of times judges aren't trying to question you to trick you. Most of the times they're not. A lot of times what judges are trying to do is persuade the other judges to their viewpoint and using the attorney, who they agree with, to make the point for them. So I was trying to get her to say, well, isn't it foreseeable because she talked about a student, a fellow student, then therefore she could have reasonably foreseen that it would disrupt the school. It was targeted. And Audrey ran with that. She knew I was trying to help her. She took that life preserver.
You guys didn't get to see a petitioner go, then a respondent, and then a petitioner have a rebuttal. If you are the respondent, don't forget that if a judge asks a specific question to the petitioner, because they often will, that will help your case as the respondent, answer the question for the judge. get up, say, Judge, I would like to address a question that you posed to the petitioner, XYZ, and then answer that question, then get on with your case, and then kind of stay on your track. And then the petitioner will have their 5 or 3 or however much time for rebuttal that they want. So if you don't think that the petitioner addresses an answer well, or it's a question, use that, what the judge is trying to ask, use it to say, oh, by the way, Judge, that really helps my case, and here's how it helps. And kind of expound on that for them. Sorry you didn't get to see that side of it.
I have one question. You started off, how did you decide where to start off? Because where you start off, your roadmap is so important. Everything else will flow from that anyways. You started off very strong. What did you
Always start with may it please the court, and I think they might talk about that a little bit more. Then tell who you are kind of representing and representing the respondents so that they know, even though they're going to know, you need to remind them. I always do a little bit of procedural history just to kind of trigger the judge's mind. Whether the petitioner does it or not, I always do it as a respondent as well. I give a quick intro too. You kind of heard that with the First Amendment to the Constitution provides. Tinker is the applicable case here. That was my intro. Whether you state the issue or not, the petitioner is probably going to state that. And then I get into a roadmap, and I always find that very, very crucial. It helps the judges follow your train of thought, and it also helps keep you on track about your points. So my roadmap was for the following 3 reasons Tinker applies. It applies to on-campus or off, the overwhelming number of lower courts, and then Tinker effectively addresses that issue. We didn't really get into maybe that. That was kind of the foreseeability. But you saw how I got taken off of that very, very quickly in Professor DeNoyer's very first question. So your roadmap helps you know where to go and helps organize your arguments. It helps the judges tremendously understand where your argument is because each one of you have a different style. And then it helps you get back on track when a judge throws you off with a question.
Yeah. Don't be married to your roadmap, though, because
I won't get to stay on it.
I deliberately try to throw her off the roadmap right from we get started. And because that's what will often happen because the judge wants to know about something. And what you want to make sure you're doing is you're not arguing to the judge. You're there to have a conversation with them and talk to them and be a counselor to them. And so the judge will often come in and instead of arguing with you about point 1, and I'm going to argue you, they're there with questions. Well, my only question relates to point 3, so I'm going to ask that one. And I'm not going to worry about you talking about point 1 and 2. And when I'm done with the question on point 3, you can go back to 1 and 2 if you want. But that was why I asked that question first. That's what I cared about. So it may not go in the order you want, but it is important to know the argument and do the layout for your own benefits so you will know the structure so that you can always, first of all, write it out to a degree. And you're not going to write it out like it's a speech. You get your bullet points down. And then importantly that you can pull out those different bullet points and know when I can go back to them. What bullet point am I moving to now? Okay, I'm moving to this bullet point. Now I can go back to this one. And you have to transition back to it effortlessly. You can just say, now regarding point 1, and just go right back to it. Have some sort of phrase that triggers that you're going to now transition. And it'll help you transition from the question being asked to the judge, by the judge, to what you're talking about initially, what you want to talk about.
And also, just a tip and a trick. You heard me say, I'm sorry, Your Honor, I don't understand your question. One, that makes the judge rephrase their question. If you truly don't understand the question, ask it. But if you need a second to formulate your answer, it is always a very good thing to say, I'm sorry, Your Honor, I don't understand your question. It gives you a second, it makes them restate their question, and then, I truly didn't understand this question, really, even though I knew it was coming.
Why would you?
So I just asked for a rephrasing, and that sometimes can give you a little reprieve to kind of collect yourself from, oh my gosh, I didn't understand his question, to, okay, now I can give a reasonable, logical argument to the judge of why my side should prevail. Any other questions?
What happens whenever the judge just isn't buying your argument? You just look on their face, or just they're on their eyes, or leaning back in the chair? Whenever you can kind of pick up on the fact that you find nothing persuasive, what can you do?
I kind of semi-have this happen to me. Stick to your points. You gotta You have your points, you know what your case law is, you know what your facts are, you know what your policy reasons are. Stick to them and don't get tricked into changing your argument. And they're not trying to trick you, it's just there are two really plausible answers to where you're trying to go, and you want to stay on your side and not give in. Just because they're not buying it doesn't mean that the other judges aren't. So stay on your point.
Also, don't put too much emphasis on the way a judge's face looks. I mean, they may look like they're not buying your argument. It may just be 9:30 and they're tired. They worked all day and then they came and they're volunteering to do this for us. They've heard this argument over and over again. You may be presenting the exact same argument two other people have presented before you. So just don't lose faith in your argument just because a judge looks disinterested. You're making this argument for a reason, and that reason persists regardless of a frowny face.
I knew a judge who looked like he was always sleeping on the bench. He would lay back in his chair and close his eyes. I think he was just really meditating on the issues at hand. And people didn't always pick up on that. And so you got to keep going. It's like when you're giving, if you're people who are acting, and, they're going through a really unfunny skit on Saturday Night Live, and yet the best people always keep acting normal. They keep going through it. That's what you have to do, and just make sure you make those points. And you have confidence in what you're actually saying, then the judge will believe you. And if the judge doesn't believe you, well, you have the other two judges.
And keep in mind, you don't have to convince the judge to win.
Not in moot court.
Not in moot court. In real court you do. But in moot court, to do well, you only have to present your argument as capably and as well as you can and hope that your argument is a sound one. And a judge may look at you, well, they lost, but they did a really great job and score you highly.
Just a final note on how to prepare. I have 4 loose sheets of paper. I don't suggest that. You can basically figure out how it works best for you, but I would try and keep your arguments, your notes, to 2 pages, so you can either have them straight up in front of you or staple them to an envelope or to a manila folder so that you can start here's your intro, I'm finished with my intro and my roadmap, open it up, and you have 2 pages right there that are your arguments and your conclusion and your cases and all of that kind of stuff. And you will be shocked how well you'll know it up here, and you won't have to look here. So just a little kind of arguing tip or organization tip. Don't fumble with your papers, basically. Anyone else?
Other questions?
Now that our demonstrator is done, Tracy Johnson, she's going to come here and talk a little bit about courtroom decorum, how to address the judges, what to wear, more importantly, what not to do.
Okay, guys, so I knew I was talking about some of that, but not all of it, so I'm going to try to share with you what he said. If I forget something, let me know. I think that the most important thing that you need to do is know your information. And in doing that, you will give yourself the confidence and the decorum that you need to stand in front of the judges and give your argument to them in the most compelling and convincing way. That being said, there are some things that you can do that will be highly distracting, and you may think that they're helping you. One of them is the way that you dress. I know that a bright colored tie and fancy shoes are very tempting. I own a lot of fancy shoes, a few ties. But make sure that you are dressing in the most professional manner. You should not have on ridiculous shoes. You should not have on ridiculous jewelry. And you should not have on a brightly colored tie or a shiny tie tack or the biggest bling, what are those called? Cufflinks that you can find. So try to keep it toned down. It will help you be less distracted because you'll be worrying less about what is happening to your outfit. And this happens. I've seen people be up here and they'll be like, oh, is my tie straight? Is my shirt? What are my pants doing? Are they long enough to cover my shoes? Don't do that. It's distracting. Find some other thing to do that will help calm your nerves and mess with your clothes. So I suggest you pick out your clothes. That being said, if you have a question about whether or not something is acceptable, it's not. That's it. If you look at it and you're like, I wonder, it's not. pick something else. That's the answer. I would give you my email to ask me, but don't wear it. Okay, so now a little bit about the argument, which is the more important thing. Andrew Blackwell was going to share with you a lot of information about how to address the court, so I'm going to try to do that as well. Whenever you walk in, it's not going to be as formal as you think it is. You should still act very professional, but you should not be overwhelmed by the formality of the room and the judges. Whenever you walk in, you can go up to the podium, make yourself at home, put your stuff down, look at the judges. If they're writing, step back, relax, wait on them, take a breath. Whenever they look like they're done, maybe they'll tell you that they're ready for you. You can step back up, and no matter what they've said up to this point, if they've told you they're ready or not, you always begin with "May it please the court." And they'll say yes, and you'll begin. That is very important. A lot of these things that I have written down here from Andrew Blackwell are things that Audrey did a very good job of, and so it might be a little repetitive to you, but I'm going to run down my list so that maybe you can have them all together. So whenever the judge asks you a question, stop immediately. No matter if you are in the middle of a sentence, stop immediately. And answer them as succinctly as you can when you start out answering, with a yes or a no if possible. Audrey did that a couple of times. She said, yes, that is one of the reasons, and also these 10 other things that help my case. So start like that in answering their questions. And one of the things that I found to be most challenging when doing the oral argument in one-on moot court was how to get back into your argument. Because once you answer the question, no matter how eloquently you answered it, it doesn't look really great whenever you're like, yes, Your Honor, this and this and this and this. And now I'm going to talk about, so kind of think about that, like kind of try to anticipate some of the questions. Like, you know what the hot button issues are. You know what the questions are from the case law that you have. So try to figure out what you think they might want to know about, and know what every one of those things relates to. What element is this relating to? So you can say, yes, these help my case, and they speak to foreseeability for this. Now back to the first point that goes along with foreseeability. And you can get yourself back into it. And it seems like that's something that's very simple, but it's something that you should prepare for, because whenever you're there, it's not that simple. It's very easy to get flustered. And honesty, like they said, always answer truthfully. If there is a case that goes against, well, isn't it true that this is against your argument? Yes, Your Honor, it is, but this case is distinguishable from this situation because. Always answer honestly. Don't try to, well, maybe if I don't say, yes, it is bad for me, and I try to answer, they'll get confused. Don't try to confuse them. That's a bad tactic. Okay, so they talked about when the judge tries to throw you a bone and help you out. It's very true that they are likely to be helping you, so take that, especially if you feel like you're struggling. There are a lot of judges who will empathize with you and will be like, let me help you. So take that. And the last thing, kind of a big pet peeve of everyone that I have talked to that is involved with moot court in any way, whenever your time expires, like the bailiff will be there, they'll have the cards. When they hold up the 0, it's a red card, stop talking. No matter what you're saying, stop talking. And say, if the judges have not noticed that your time expired, Your Honors, I see that my time is expired. May I conclude my statement? And they'll say yes or no. If you are not in your conclusion because you've gone on too long about one of the other elements, maybe ask, may I finish my statement and conclude? And whenever you ask this, you finish the one sentence that you were in the middle of when your time expired. And you ask the court for the relief that you want for your conclusion. That is the only conclusion that you can give after the 0 goes up. Audrey gave a great conclusion, and she wasn't running against a time. But that conclusion that was beautiful, don't give that, no matter how well long for a statement after your time has expired. Do you guys have any questions about that? I see people do that all the time. I bailiff a lot, and I put up the 0 and they just keep going. The judges don't like it. Why am I using that? I'm just going to give you an example of what your statement might be.
So I'll just go from mine. Where is it? Thank you. Disorganization here. So my whole conclusion was 2 sentences long, but if you're after your time, just say, I ask that this court uphold the ruling of the 14th Circuit. Thank you. Be out.
Yeah, that's it. That's short. So a conclusion after time is not the same as a conclusion that you may have prepared, assuming that you would get through all of your elements. And if you don't get through all of your elements, there's not a need to despair. If you're answering the judge's questions, you see that your time has run out, it's not about finishing, it's about doing a good job of what the judges are interested in. So I think that that is all that I have for you guys. Do you guys have any questions for myself or the directors?
So how do you handle it if you have a question from the judge and your time runs out while you're answering?
If your time runs out, you definitely stop and you say, I see that my time has run out. Would it be okay for me to finish answering your question? And then you really do need to make it short. And if you want to finish answering their question and conclude, you should ask to finish answering the question and conclude. So try to be aware of that whenever you're asking for more time. You need to ask for exactly what you want. And if you forget to ask for exactly what you want, only do what you've been given permission for. Anybody else? Yeah.
I had a question about organization and kind of go off your presentation as well. When you kind of said that when a judge asks you a question and it's on a different point, you said to kind of finish that point and then go back. Now, what if, I'm not sure how many judges we'll have, but what if we have 3 different judges, have 3 different questions on 3 different points? How do you go about that if they're asking you questions on?
You follow the judge's question.
Okay. So
And then you figure out how to get back on your roadmap.
Okay.
It
So
can be kind of difficult, but you'll see that you'll answer the question and there might be a follow-up question. You'll answer a question, there might be a follow-up question. And so you just, depending on whether it's a hot bench or a cold bench, you'll figure it out pretty quick. You'll be able to just either go down your roadmap, get through your entire first set, and then a judge will ask a question about a third one. Or you'll be in your third element and a judge will ask a question about your first element, which you've already finished. Answer the question. Don't skirt the judge's question.
Yeah. One more thing on that. If the judges ask you questions, like you're answering one judge's question and judge number 2 interrupts your answer, it's really impressive if you can remember to go back and finish your original answer. You have to be tactful about it, but if you are addressing the element of foreseeability, well, what about this case? And you're like, oh, I'm not done yet talking about this. Then answer the most recent question asked, and then that judge will be impressed if you say, did that answer your question, judge number 2? Yes, it did. Judge number 1, back to your question. That is nice.
And that's kind of why it's the roadmap is so important. When you get peppered with questions, and very often the judges will be aiming at your weak points, which I highly suggest you put late in your argument. So if there's something you don't get to, it's your crummy arguments instead of your great arguments.
Yeah.
And so if you come out and you start your roadmap with, hey, this is my best argument, these are my great cases, and they hit you at your weak points, always come back to your strong argument after you've completed answering their questions. If you have to let go of those lower elements of your roadmap because of time, that's fine. Let those go. Focus on your strong argument because the judges are asking you the questions they need answers to about your weaker arguments that you're leaving to cut off in case of time.
You're kind of saying judge number 2, judge number 1. Are they going to tell you their names whenever you come in so that you can address them personally? So how would you do that? You're just like, judge, just try and point out to them.
I mean, it'll be like, Your Honor, have I answered your question? Or you'll be looking at them. So it's really about your body language. Be like, have I answered your question? Now back to your question. And that's, you're just going to have to kind of control it. It's not exactly like the real situation where you would know the judges' names, but it's also not as formal as that, so you can kind of take a breath about it too. There's good and bad to that.
And keep in mind, you'll be relatively close to them. The furthest away you'll be from your judges is the distance between Tracy and this young man in the plaid shirt. The judges will be sitting right up there in this room, and that's the longest distance. So it's more like a conversation and less like a tribunal. So you'll just be able to look at them. Your Honor, is that sufficient to answer your question? Your Honor, you were talking about, and that will work easier than you think it will right now. No.
I just have one last thing to add, because it's something I get in trouble for, and you saw me do it when I was standing here, using my hands a lot and moving them and talking with them, and a lot of people are tempted to talk with their hands and use them. I get in trouble for it a lot. If you have that problem, clasp them in front of you, only unlock them to turn your page, hold on to the podium, place them on the side of the desk. Don't flail your hands with your argument. Trust me, you'll get a comment on it if you do it. It happens to me. Also, don't sidestep around. I tend to do that too. I had to do that here because Professor Denoyer was on my side. But don't wiggle around a lot. Stay. You don't have to be a complete statue. You can use your hands a little bit, but don't overly do it because you'll get comments on it and it'll be distracting, and you don't want to do that.
I'll just do like an argument in return.
As far as preparation goes, what would you recommend for somebody who talks about this?
Practice talking twice as slow as you will in your argument. Just practice. Practice slow. Tell yourself when you get up there, slow down. Or if a judge is asking a question and you catch yourself speeding up and going really fast, stop. Like, just take a breath. Don't cut yourself off in the middle of a sentence, but if a judge is asking a question, just remind yourself, slow down, or at the top of your notes, write, speak slowly. That's something I do as well. You'll notice that even if you think you're slow, you'll get faster in an argument. And I've seen you do it, so I know you do. But yeah, just practice slower than you think. Remind yourself to slow down and speak clearly and just kind of pull yourself back. That's something that you personally have to watch and rein yourself in on.
Yeah, and there are a lot of judges in the competitions. I have run into this, and if you, for whatever reason, whenever a judge can't necessarily hear you, some of them will tell you, some of them won't. It'll just be like, couldn't hear anything you said. I have never gotten this comment, but I have gotten the speed, you're going way too fast comment. I try to imagine that someone is handwriting what I'm saying. So if you were taking notes on what I was saying right now, you see how the speed of what I'm saying has slowed down immensely from me giving you my previous responses to your questions. Okay. Do you guys have any other questions?
How many minutes do they have for oral arguments? How many minutes?
20 minutes.
20 each?
Yeah, 20 minutes each. The petitioner, the petitioner will be able to reserve up to 5 minutes, which you will do at the beginning of your argument.
Just run through that.
That will just be, Your Honor, I represent the petitioner. I'd like to reserve 3 minutes for my rebuttal at the end of the respondent's argument. May it please the court.
If you're the petitioner, reserve rebuttal time. Do it.
Because they will say something that you have an excellent argument against, and that last word in the judge's mind is in your favor.
Okay, if you guys have any questions beyond this, I see that we're running low on time. I want to give you a couple of email addresses. The first one, does everyone have a pen? The first address is the number 1 lmc.mulaw@gmail.com. That will be answered by one of the assistant directors or the directors And the other one is my email address. I'm going to write it up here. Sometimes these letters are mispronounced. That's my paw print. It's at missouri.edu, mail.missouri.edu. If you guys have questions about, I mean, I can't help you with your argument, but if you have questions about the process or organization or anything like that, and this goes throughout the competition too, if you find yourself moving on and you have questions about that, you can email the 1lmc.mulaw@gmail, or you can email me. I'm standing right in front of it since I told you. So if you have any more, let me know.
And one last thing, everybody, before we leave. Once again, sign-up for practice rounds must be done by 5 p.m. today. Your room assignments for the rest of the week for your practice round will come later this evening. Do not be late for your practice round, and be very nice to your practice judge. They will give you much more directed feedback than we were able to give you today. Thank you all for coming, and we'll see you later this week.